Which witnesses will you have?
Your Honor, if we're talking about the in-camera hearing, we'll have Mark Tinsley, and we do have another issue which I believe I had indicated to Your Honor perhaps in a pretrial conversation as to a conversation that took place a few days after the crimes occurred, in which there were a number of individuals present. Mr. Murdaugh was present. I don't know the contents of that meeting because I've been out of an abundance of caution, have stayed away from that, and I believe that we may have a little bit of testimony just on whether or not there is any attorney-client privilege to that conversation. I've been careful throughout this investigation preparation not to be privy to that, but I do believe that it is not an attorney-client privilege conversation, but I'd like the court's ruling on that before I became privy to the contents of that. That's the only other issue at this time that I think would be addressed in camera that morning.
Your Honor, and sort of a surprise here, were those conversations recorded?
No. And I mentioned this in our pre-trial.
Yeah, I just didn't know what you're referring to. Neither one of us know what the contents of those conversations are.
I believe Mr. Griffin was present at this meeting, which is exactly why I wanted the court's ruling before I became privy to the contents of the defendant's statements at that meeting.
We're not quite sure, but we'll wait with bated breath to hear whatever it is.
Can you be more specific as to what you're talking about, Mr. Waters?
From my understanding, there was a meeting or some sort of gathering in which Mr. Griffin and Mr. Murdaugh and then a number of other individuals were present, in which the defendant made some statements. The contents.
Individuals?
No. I think some of his partners and other individuals, maybe some family, to which I have never been privy to the contents. However, I would like to know the contents, but I've been careful out of an abundance of caution not to ever become privy until I had a ruling from the court that there was no attorney-client privilege because of the presence of third parties to that conversation. So I would like to address that with the court, and if the court believes that and rules that there is no attorney-client privilege, then I may, at the appropriate time, examine people who were present at that conversation as to what the defendant said.
And is that in relation to financial crimes or?
No, sir. That would be in relation to the murders of Maggie and Paul. But it is an in-camera matter that if we have the time available, I wanted to raise that with the court. Maybe we can go ahead and knock that one out as well.
All right. Any thoughts by the defense?
Your Honor, what he's referring to is, it was on Thursday, June the 10th, when SLED came to John Marvin Murdaugh's hunting property to interview Alec, to interview John Marvin Murdaugh, Randy Murdaugh, Buster Murdaugh, and I was there to represent Alec for purposes of that. Before SLED got there, we were all in the house. I have no idea what beyond that he's talking about. I mean, what was supposedly said or heard, or I have no idea, but beyond that. I don't know of any conversations that he's trying to find the substance of and who he's going to get them from. And
Your Honor, I think that's just it. We would have a witness as to the circumstances of who was present, and in the event that Your Honor rules that because of the presence of third parties, it was not a protected conversation, then I would become privy or asked to become privy to the content of that. And again, that isn't
by inquiring of who?
Well, the witness who were present, and so I'm going to call one of those, which
the law
could be
partners.
Exactly. And again, I wouldn't even have to do that on the stand. I would just want Your Honor's blessing before I did that because of an abundance of caution and protection of the attorney-client privilege. At that point, I could, offline become privy to the content of it. It may be nothing. I've just been told that there was that meeting and the circumstances of it, and I don't believe it's protected, and so I'd like to know, what the defendant said at that meeting.
Yes, sir.
sounds like he's asking for a deposition, Your Honor. And he's got no right to an evidentiary hearing about what happened at a meeting in the course of a trial. He's got no right to compel people to come testify so we can find out what was said. That's discovery. I mean, State grand jury allows him to do that, but there's no rule that permits him to conduct a deposition, whether in court or out of court, and that's what he's trying to do.
Not asking to conduct a deposition, Your Honor. I've actually been doing this out of abundance of caution and protection of the defendant's rights and making sure that we didn't cross the line without the court's input. And again, the content may be something that's useful or not.
Well, if you'd like to brief or send a memo or cases to the court regarding statements made in the presence of counsel and third parties, whether that's protected by attorney-client privilege or not, then the court can address the issue.
Yes, sir, Your Honor, and I'll be happy to address that Monday morning. I will. I do have a case, Marshall v. Marshall, 320 Southeastern 2nd 44, which just generally, of course, states the rule that if attorney-client privilege communications are related in the presence of third parties, then the protection is lost. And I can go ahead and hand that one up to Your Honor, and I certainly be prepared to address that in any great detail. Let me look at this case, and obviously, if we prepare additional ones over the week, I'll provide those to Your Honor and counsel.
Anything further?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, we'll be in recess till 9:30.
All right.